What truly defines a nation? I mean, really makes it exist? Is it just, the lines we draw on a map, the physical shape?
Or is it something, well, deeper, like
Right.
the people themselves and the rules that bind them together?
Exactly. Today, we're doing a deep dive into the real foundations of India's nationhood, right back at its birth. We're looking at the very first articles of the Indian Constitution, specifically the parts about the Union and its territory and citizenship.
And our sources for this are, well, they're direct excerpts from the Constitution itself. Nothing else.
Right. The mission is to uncover the precise legal definitions, the rules they set up right at the commencement, as they called it. Who was an Indian citizen then? What was India's territory? This is sort of your shortcut to understanding these really crucial foundational bits, things often overlooked. Okay, so let's dive in. The Constitution, it doesn't waste any time. Article 1, Clause 1, it just states it right there. India, that is Bharat, shall be a union of states. Simple as that.
Very direct.
And then Article 1, Clause 2, it clarifies that the specific states, their territories are all listed out in the first schedule, the official list.
Right. It formalizes it.
Then Clause 3 gets even more specific about what counts as Indian territory. It's the territories of the states, the union territories specified in the first schedule, and also, this is interesting, such other territories as may be acquired.
And what's truly fascinating there is the flexibility they built in right from the start about territory, even while calling it a union of states. It wasn't set in stone. Article 2, for instance, it gives Parliament this pretty broad power. It says Parliament can admit into the Union or establish new states on such terms and conditions as it thinks fit.
Which makes sense.
Yeah.
For a new nation.
Yeah.
Especially thinking about the princely states maybe joining later.
Absolutely. Very pragmatic. And then Article 3 gives Parliament even more power by law. They can form a new state by carving up territory or uniting states or adding territory to a state. They can also increase or decrease the area of any state or change its borders or even its name. It's quite a powerful set of tools.
And here's where you really see that adaptability in action. There's this mention of an Article 2A in the source material. It was about Sikkim to be associated with a union. But then right next to it, it says, "Rup by the Constitution, 36th Amendment Act, 1975. What's rup-a-by mean here?
That means it was repealed. Officially removed by a later constitutional amendment in 1975 when Sikkim fully became a state. The fact that they even had mechanisms like this, allowing for association first and then full integration or change later, it shows remarkable foresight.
Yeah.
They knew the map wasn't finished, born out of partition, integrating states. It had to be a living document, allowing changes to avoid, well, future conflict over rigidity.
But it wasn't just unlimited power for Parliament, right? There were checks.
Oh, definitely. Crucial checks and balances. The proviso to Article 3 is key. A proviso is basically a condition attached.
Yeah.
Any bill for these kinds of territorial changes needs the president's recommendation first.
Okay.
And this is important. If the bill affects the area, boundaries, or name of an existing state, the president has to send it to that state's legislature. They get to express their views within a set time. It's not a veto, mind you, but their voice has to be heard.
Right. They get a say.
Exactly. And there are a couple of explanations in Article 3 just for clarity. Explanation IO says that when Parliament uses its power to change areas, boundaries, or names those clauses, A to E state, also includes a union territory.
Okay.
But for that proviso where the bill goes to the legislature, state does not include a union territory. So UTs don't get that specific referral right.
Interesting distinction.
And Explanation 2 clarifies that Parliament's power to form new states under Clause A also includes forming a new union territory, maybe by uniting parts of existing states or UTs.
So what does this all mean for you listening today? It means these first few articles, they laid the groundwork for India's, well, constantly changing map and administration. It wasn't static. It was designed to be flexible, to integrate, to adapt. Really highlights that practical vision.
Absolutely. And Article 4 kind of seals that practicality. It says any law made under Article 2 or 3 admitting or changing states has to include changes to the first and fourth schedules.
The lists of states and their representation in Parliament, basically.
Precisely. And crucially, Article 4 says such a law is not considered an amendment to the Constitution under the terms of Article 368.
And Article 368 is the big one, the tough amendment process.
That's the one. Often needs supermajorities, much harder to pass. So making territorial adjustments easier, not requiring that heavy process, was actually a brilliant bit of legal engineering. It allowed necessary administrative tweaks without constitutional upheaval.
Okay, so the physical blueprint, the territory,
Right.
was laid out with, remarkable foresight. But a nation isn't just land. It's the people.
Hmm.
And defining who belonged, especially right after partition, that must have been incredibly sensitive. So the territory is defined, but who are the people living there?
Indeed, that was the immediate next step. The Constitution had to define citizenship right at its commencement when it officially started. Article 5 sets out the main rule. Anyone whose permanent home, their domicile, was in India at that moment was a citizen if they were born in India, simple enough,
Okay,
or if either of their parents was born in India,
right.
or if they'd just been ordinarily resident in India for at least 5 years right before the Constitution started. Those are the sort of broad strokes for people already rooted there.
Now, here's where it gets really complicated, reflecting that awful reality of partition. How did they possibly handle the massive population shifts, the displacement?
They couldn't ignore it. They had to create specific rules for migrants. Article 6 deals with people who migrated from what was then Pakistan to India.
Okay, coming into India.
Right. Such a person could be a citizen if first they or their parents or even their grandparents were born in India as defined by the old 1935 Government of India Act. That was the baseline connection.
Gagging.
And D, it depended on when they migrated. If they came before July 19th, 1948, they just had to have been ordinarily resident in India since they arrived.
Simply for the early movers.
Relatively. But if they migrated on or after July 19th, 1948, there were more hoops. They had to actually register as a citizen. They needed an application approved by an officer submitted before the Constitution began. And crucially, they had to prove they'd been resident in India for at least 6 months right before applying.
Wow, okay. Quite specific dates and conditions.
Very specific. Then Article 7 handles the other flow people migrating from India to the territory that became Pakistan. Generally, if someone migrated after March 1st, 1947, they were not considered a citizen of India. That date is key, reflecting the post-partition movement.
So leaving India after that date generally meant losing Indian citizenship status under these initial rules.
That was the general rule. But this raises an important question. What if someone went to Pakistan but then came back?
Changed their mind, maybe.
Exactly. The proviso to Article 7 addresses this. That general rule didn't apply if someone returned to India under a proper permit for resettlement or permanent return. For those individuals, the law basically treated them as if they had migrated after July 19th, 1948, for the purpose of Article 6b.
Meaning they'd still need to go through that registration process you mentioned earlier.
Correct. They had a path back, but it was a formal, structured one requiring registration.
Okay, that covers people moving across the new borders.
Yeah.
But what about people of Indian origin who were living elsewhere, around the world?
Good point. Article 8 handles that. If a person or their parents or grandparents were born in India, again, under the 1935 Act definition, and they were ordinarily living outside India, they could be deemed a citizen if they registered with an Indian diplomatic or consular representative in whatever country they were living in.
So a way to connect with the diaspora right from the start.
Vital for maintaining that connection, yes.
Okay, lots of ways to be a citizen at the beginning.
Yeah.
But let's unpack this. What if someone tried to be a citizen of India and another country at the same time? Dual citizenship.
Article 9 is crystal clear on that, at least at commencement. It says no person could be a citizen under these initial rules if they had voluntarily acquired the citizenship of any foreign state.
So no dual nationality allowed under these founding provisions.
Absolutely unambiguous. It was a choice. Indian citizenship or foreign citizenship, not both at that point.
And what about the future? Were these rules set in stone forever?
No, and that's crucial. Article 10 ensures that citizenship acquired under these articles 5 through 8 would continue, but, and it's a big but, it's subject to the provisions of any law that may be made by Parliament.
Meaning Parliament can change the rules later.
Precisely. And Article 11 confirms that explicitly. It gives Parliament the full power to make any law about acquiring or losing citizenship and basically all other matters relating to citizenship. So these initial articles, 5 to 9, were about establishing citizenship at commencement, dealing with the immediate aftermath of independence and partition. But Parliament got the ultimate ongoing authority to legislate on citizenship moving forward.
It's really quite something how these first few articles just meticulously laid out both the physical space the territory and the human element, the citizens of this new nation. And you can really see how tangled up territory and citizenship were right at the start,
Yeah.
especially with partition casting such a long shadow.
Deeply intertwined, yes.
Understanding these foundational legal definitions, it really gives you a unique lens, doesn't it? For looking at how India developed later, the debates about identity, borders, it's not just dry historical text, it feels like the bedrock. Knowing this gives you context for today's discussions.
Absolutely. And if we connect this to the bigger picture, I mean, considering how carefully they handled territory, how detailed the initial citizenship rules were, all written in the immediate aftermath of partition, it makes you wonder, though, what are the lasting impacts, maybe the challenges, when a nation's founding documents are shaped so profoundly by such a huge traumatic event? Millions displaced, new borders.
Yeah.
What does it tell us about the power, maybe, but also the limits of using legal frameworks to define something as complex, as personal as identity and belonging?